SJC-13777, Matthew Ortins et al. Versus Lincoln Property Company et al.
Okay, Attorney Salveson.
Yes. Good morning, Your Honors. May it please the Court. Doug Salveson for the Massachusetts IOLTA Committee. With me is Jenna Myra, the Executive Director of the committee. The very first time that the committee received any notice of this matter was 2 years after the final hearing on approval of the settlement agreement, when the parties were before Judge Howe seeking to have $500,000 returned from unclaimed settlement funds back to the defendants. There was a hearing before Judge Howe. She made two findings. She found that Rule 23E had been violated in two respects. The committee did not receive notice before the approval, and the return of any of the residual funds to the defendants was a violation of Rule 23. She reluctantly declined to unwind or disturb the settlement agreement. She did that because she believed that the settlement agreement that was before her had been presented to Judge Liu, that the provision regarding the residual funds had been considered by him, had been discussed, and that he had approved it. She did not have the transcripts of those hearings. This court does. Those transcripts show that he likely did not approve this particular agreement that was before Judge Howe. He never saw the provision on the residual funds returning $500,000.
He raised 23E though, correct?
I'm sorry?
You raised IOLTA's notice, correct?
It was discussed as an aside early on in the preliminary hearings, but none of the parties pointed out that the IOLTA committee needed to have notice of the hearing before it was approved.
But he seems to have been aware of the basic principle, which was that the cypre relief, as the basic principle of the identity of the recipient or recipients of the cypre relief under the settlement. And he was dissatisfied with the original proposal. And in that mix, he mentioned IOLTA and other organizations.
The original agreement presented to him is much different, and the only agreement he apparently ever saw is much different than the agreement that's before this court. The agreement that he saw contained paragraph 36, which dealt with the residual payment. In the original agreement, the settlement agreement called for a $4 million settlement. Paragraph 36 said if there's any money left over from the $4 million, the first $100,000 goes to a cypre recipient. All the rest of the $4 million goes to the defendants. That's the only provision he ever saw. He objected to that right away. He said that could potentially be a large amount of money. It was very problematic. It made the settlement agreement unfair. So he refused to approve it preliminarily. They sought to assuage his concerns. They really overstated the expected participation rate of the class members. They told him, of this $4 million, almost all of it is going to go back to the class members because we expect 95% of the class members to participate in the claims made procedure, which is just insane. He jumped on that and he said, well, I guess you don't expect a lot of money back from this $4 million. And they said, we really don't. He said, do you expect, less than $500,000 back? They said, yes. He jumped on that and he said, well, I'm going to set a cap. Of the $4 million, I'm going to say only $500,000 can ever go back to the defendants. They didn't agree to that. They came back to him and they said, how about $700,000 at one of the hearings? He said, no, I'm not going to allow that. That would make the whole settlement agreement unfair. If of the $4 million, less than $3.5 million went to the class members or to a Cypre recipient, that would be unfair. So I'm setting a guardrail. The guardrail for my reasonableness analysis is $500,000. Anything more than that that goes back to the defendants, I consider this settlement to be unfair. The agreement that Judge Howe enforced doesn't have that cap. There's no cap on the $4 million because what happened is they rewrote paragraph 36. They rewrote that provision. They didn't advise Judge Liu they were doing it. They never discussed it at any of the hearings. And what they did is they took the cap that was on the $4 million settlement and they put that $500,000 cap that Judge Liu insisted on something called the settlement fund. Now, the settlement fund is this temporary pool of money that the claims administrator would use to fund claims as they came in. It had to be funded initially with $800,000, and the defendants were required to put more money in if claims required more money to be put into the account. So they put a $500,000 cap on $800,000. And that's what happened.
Can I shift you just one, and I get this point, but you don't have standing to contest the agreement itself. You have standing to weigh in on the residual funds, right?
Yes.
What are the residual, in your understanding, what does residual funds include? Because I have a little trouble with that, because I think you have a different sense of residual funds than he has. But go ahead. Mm-hmm.
I think the first thing, it's easy to say residual funds are not whatever the parties to a settlement agreement decide they are and define them that way. The residual funds are defined in Rule 23E1 and says residual funds are funds that remain after the payment of all approved class member claims, expenses, litigation costs, attorney's fees, and other court-approved disbursements to implement the relief granted. Now, I think the only way to understand that is to go back to the first couple of words. Residual funds are funds that remain. Remain from what? Okay?
But the difficulty for that argument is that there's also a sentence in the rule that explicitly says parties are not required to.
I will absolutely get to that because I think that's important too. But the residual funds remain from what? And I think my understanding is they remain from the relief granted in the settlement agreement. So if the settlement agreement grants relief of $4 million, the residual funds are funds that remain from that.
Well, this settlement agreement granted relief in the form of, quote, up to $4.6 million pursuant to a bunch of provisions, including this $500,000 pushback. So arguably what the judge approved was just an amount up to 4.6 pursuant to all of the provisions. So can you address that?
I don't think that's at all what Judge Liu understood. Judge Liu, in the paragraph 36 that was presented to him, understood that there was a $4 million cash settlement amount and that they were going to get back at most $500,000. So he understood that there was going to be at least $3.5 million that went either to the class members or to the Cypre recipients. Now, to get to the second point about the second sentence in that 23.
So are you arguing that under Rule 23, this was an unlawful settlement?
It depends which settlement agreement we're talking
The
about.
one that was approved that says that the settlement is up to 4.6 pursuant to, et cetera.
My point is, I don't think that was ever approved by.
What was the settlement agreement that was attached as Exhibit A to the order of giving final approval? Because that's not in the record, but there was an actual settlement agreement attached to the final order.
There was.
And that will answer this question as to what Judge Liu approved. So perhaps you could submit that in a supplemental submission.
No.
Is it something other than,
Yes, the day after the final hearing, there was my understanding is there was an email sent by the plaintiff's counsel to the clerk because the judge had asked for a form of order approving the settlement agreement. As part of that email, there was a form of order, and then also there was this settlement agreement, which was a settlement agreement that was before Judge Howe. But that settlement agreement was never discussed at the three preliminary hearings and final hearing.
the order says that Judge Liu in his order says he's reviewed the one that's attached to the order.
It's
And
hard.
you're asking us to discredit that statement.
It goes against everything he said at all of the four hearings before him.
Does that matter?
Consider it
It doesn't matter. I enter an order saying this is the one I approve. It's the Exhibit A, regardless of whether I, thought, I'm concerned about the 500,000 back. I'm concerned about the particular Cypre recipient. I don't. All we take is the final order.
Well, yeah, that's
So who has that exhibit? Do you have it?
I do have a copy.
Oh, okay, great.
Well, I have a copy of the email because it was very unusual to me.
No, I guess I'm concerned about what was attached to the final approval order.
The draft final approval order had the agreement that was before Judge Howe.
Okay,
Which is
so,
one. Okay. Okay.
But it was an agreement that was never discussed before Judge Liu, and the terms of it were explicitly the opposite of what he said he required and what he would find to be reasonable as a settlement.
Can I ask you about the remedy for the violation of the notice provision? Is it to unwind the settlement agreement in totality, or to unwind portions of it dealing with residuals and give you a right to be heard?
Well, I think the court only has the ability to either vacate or approve a settlement. It's a voluntary contract between the parties. There's a provision in the settlement agreement that says if it's modified, the parties have the right to walk away. I would be fine with modifying it, and that's what I asked Judge Howe to do. But I think as a matter of law and what the agreement provides, you're left with vacating
it's
it
all or nothing?
and sending it back. And send it back and have a judge have a hearing that complies with Rule 23E.
Did you bring to Judge Howe's attention the fact that what was before her was never before Judge Liu?
I didn't have the transcripts, so I didn't know that. I didn't have any of the transcripts. I wasn't invited to the hearings before Judge Liu. I didn't get notice of them. The committee, the first time we learned about this was at the hearing before Judge Liu.
in terms of remedy, under Rule 23E3, there's no doubt that IOLTA is entitled to notice. Well, what it actually says is that no judgment may enter without giving IOLTA notice, which I think we can assume means that IOLTA needs to be given notice. But it specifies that the notice and that you should be allowed to be heard, but for the limited purpose of allowing the committee to be heard on whether it ought to be a recipient of any or all residual funds. That seems to me to limit the scope of what you can challenge now. And so in terms of remedy, why doesn't that cabin what we can do here? Even if we were to agree that the failure to give you notice gives you standing, but your standing would be limited to that, and why isn't that the full extent of your relief.
Well, what you're leaving out, I think, Your Honor, is that the rule also says that the residual funds, no part of the residual funds can revert back to the defendants. Residual funds can only go.
I know, but that's not part of, that's something different than what IOLTA is entitled to challenge, because the rule says that you can be heard on the limited question of whether IOLTA ought to be a recipient of any or all of the residual funds, not whether anyone else should or should not be, but whether IOLTA should be.
Right, and IOLTA should be the recipient of those funds instead of the defendants. And that's what the argument would be. And that point, that this is how it slips into whether the settlement is fair or not, is Judge Liu considered the total amount, my argument is he understood that $3.5 million was going to go either to the class members or to a Cypre recipient. The piece of it that is the residuals that goes to a Cypre recipient, he considered in deciding whether or not the entire settlement was fair. So what happens to the residuals spills over into a Superior Court's judge's determination as to whether the settlement is fair. So our role is limited. We are not taking the position that the class member should get 3 times the amount that they paid as fees, or they should get 4 times the amount. We're not doing that. We're saying the money left over that is uncollected by class members, which is millions of dollars in this case, that money, under the rule, funds either Cypre recipients, nonprofit organizations aligned with the litigation, or it goes to the IOLTA committee to fund legal service programs in Massachusetts. It doesn't go back to the defendants. So they're all intertwined, and that's why it's very hard to untie them unless you have vacate the settlement and have a new hearing.
Do you concede, I assume, that IOLTA has no actual right to any money under this settlement, correct? Under any settlement. IOLTA has a right to come to be heard at this hearing. What do you think is the best case for your standing to appeal here, where you have no right to any money out of this settlement? You have only a right to be heard. And for example, there are many statutes giving, for example, victims the right to be heard in a proceeding and so forth, but they're not a party, they do not have a right to appeal. So what do you think is the best case?
Corbett case is square on this point, I believe.
Well, in Corbin, we said even though Boston's monetary interests were going to be affected by the settlement because it was going to be precluded from getting, well, I'll leave the detail, tens of thousands of dollars, they did not have standing to appeal because they were not a party.
Right, but this court also said in Corbett that the city of Boston was unlike workers' compensation insurers who did have such a right because there was a statute that gave the workers' compensation insurers the right to participate in a...
But again, those are people who are literally paying for the settlement. IOLTA is very differently situated from an insurer who's going to pay the cost of a settlement.
No, the workers' compensation insurer has the right to go into another case, and the statute gives them the right to be heard and to argue that they should get part of the settlement. And that's by statute. Here, it's by rule. So that case supports our standing here in front of the Superior Court and on appeal. In the Corbett case, the city of Boston had no right to even be in the Superior Court. And that's basically why they had no right to appeal the decision of Judge Hinkle. Here, there's a rule, specific rule that Your Honors put in place that gives the committee the right to go into Superior Court, make an argument that they should get the residual funds, and ensure that the residual funds are expended in the way that the rule requires. That's what we're asking here. Thank you, Your Honor.
Thank you. Attorney Tur? Oh, who wants to go first?
Good morning, Your Honors. May it please the court, my name is Jeffrey Turk, and I represent the defendants in this action. Your Honor, I wanted to start off by noting here that IOLTA's standing in this case is extremely limited. The rule makes clear that IOLTA only has the right to be heard on the limited purpose to allow IOLTA to be heard on whether it should be the recipient of residual funds, not to object to the settlement, not to appeal the judgment, not to object to the fairness or the claims process, but only to be heard. And that's the word that the rule uses. And yet it appears IOLTA is here today claiming that it should be the overseer as an unelected, unappointed committee to oversee all that is fair in a settlement that's already been scrutinized and approved by a judge.
Was it heard on the residual funds? Was it heard on the issue that's entitled to hearing on?
It was, Your Honor. Again, under the rule in effect at the time, which was amended because they agreed that it was unclear as to how the process should be done, they sought amendment. But the rule in effect at the time didn't set the time, didn't set the place of how it was to be done. It simply said
Didn't it
they had the
say
right to be heard.
something to the effect of no settlement shall be approved? I thought that was part of the rule language.
Says no judgment shall enter.
No judgment shall enter, and no
And-
judgment did enter.
But there's no other part of that sentence?
That's or compromise be approved.
Or compromise approved. So there was a compromise approved without the notice to IOLTA, right?
I don't believe so, Your Honor, because again, the final hearing that we had before Judge Howe was for the ultimate approval of how the monies would be returned and distributed here. And that was the rule in effect at the time.
So there was, so Howe got that wrong then. There was no law of the case until Judge Howe approved the settlement. There was no approval.
I think what the law of the case was that Judge Liu had already decided how notice would be given, because again, the rule did not, like it does now, provide a timeline.
Did Liu decide how the residual would be dispersed?
He did. He clearly decided. In fact, this is not a case where this was rubber stamped. 4 different hearings where Judge Liu explicitly discussed not only the monetary relief, but the way the cypre would be, or the residual funds would be returned. That he specifically dealt with that. In fact, if you look at the transcript, the issue of IOLTA being raised was raised to him. He wanted the funds to go to a housing-related charity because this was a housing-related case. Initially, we had suggested a veterans charity.
But I thought in response to my question, you said there was no settlement approved, whatever the magic language is, until Howe did it.
I think what the statute says is no judgment may enter.
Yes.
Judgment didn't enter until after
Correct.
this.
But what
And
happened?
compromise be approved.
Yes, compromise be approved.
Right.
So the compromise was not approved by Liu. Is that what you're saying?
I think that Judge Liu affirmed the settlement,
Yes.
did the fairness hearing,
Yes.
and all of that, but we were still required to get final approval at this last stage, which
You were looking for basically an order for distributing the funds in accordance with the settlement that had been previously approved.
correct, Your Honor.
Okay, so there was preliminary approval by Lou, final approval by Lou, and then a distribution order by Howe.
Correct.
Really, it seems to me the rub here is, it's undisputed, I think, that IOLTA did not receive notice before the compromise was finally approved by Lou.
There was the final approval. There was still another
He made
step
the
that was-
findings, he made, well, distribution, but he made, and Judge Howe did not revisit the finding on the fairness and reasonableness or adequacy of the settlement.
Correct, Your
Right?
Honor.
That was all done by Judge Liu before IOLTA received notice.
That is correct, Your Honor.
Okay.
But again, I think that what's clear here is that Judge Liu had considered this. And again, I want to be clear, they don't have standing to raise fairness. They don't have standing
Agreed.
anything other than to be heard. And that's the
And
word
that wasn't complied with,
You know, I would suggest they were heard,
not before the compromise was approved.
not before the final approval was granted, but they were heard. I also think this is a case where it's clearly harmless error if the rule was not followed.
So explain that to me.
Your Honor, I would say it's harmless error for a couple of reasons. One is because Judge Liu, again, they only had the right to ask for the residual funds to be given to them. They didn't have the right to ask how the residual funds would be determined, anything else other than that they should get the leftover money. Judge Liu clearly reviewed that explicitly. Actually, there was a portion of the transcript where he says, what about IOLTA? He wants the funds to go to the housing charity because that's who he believes would be the appropriate SJC recipient. So there's nothing to suggest that if IOLTA had been heard, Judge Liu would have suddenly said, no, I think IOLTA should get the money, not the housing-related charities that I believe should be getting the
That's
money.
not usually how we do notice an opportunity to be heard. We usually don't say, yeah, you know, the defendant didn't really have notice and opportunity, but we all know that he was guilty. Like, I mean, I know that's a totally different case, but we usually don't just say it was harmless in that way.
I think it would be different if Judge Liu
Hadn't talked about IOLTA.
and also, again,
But would that be, because not only is he not talking, IOLTA isn't there to give them the benefit of the doubt that, for example, that 94% of these people don't respond. So Judge Liu's under a misapprehension, at least from plaintiff's counsel, that the number of people are going to respond, which is actually inverse to the number of people. They're predicting 94% will respond and 6% respond. So the numbers aren't exact, and then he also doesn't have IOLTA there saying, because IOLTA brings some expertise to this, because the residual funds may include the stuff that's going back to you guys, right? I mean, Justice Dewar's questions complicates it, but I'm still not sure whether the money going back to you isn't residual funds. So if just Judge Liu thinks 94% is going to be expended and only 6% is, I'm wondering whether he's got two things wrong here.
you know, I would suggest the problem with that argument is that at final approval, he had the actual numbers. He had an accounting from the administrator saying, here's the number of responses.
Judge Liu had the final accounting as opposed to the number of pieces of paper you put out in the mail as opposed to the number of people who were actually going to collect money?
He had the exact number of people that had responded, the exact number of...
He knew only 6% of the actual injured were going to get money?
Well, I think the issue with that argument, Your Honor, is...
I'm not an argument. I just want to, does Judge Liu know, guess what? There's a very small number of people are going to get compensated. So actually the defendants are going to get off paying very little. And therefore all that money is either in a residual fund thing or it's, I don't know, it just seems like.
He does, Your Honor.
He understands that, okay.
He has the exact number of people that responded, the exact number, the exact financial number that's going to go back, and the exact number that's going to go back to.
And that's in our record? Because
that is, Your Honor. That's part of the affidavit from the claims administrator. And Your Honor, and again, I would point out the question about how you undo this settlement. What's clear here is that the plaintiff had an obligation to provide notice. That's what the rule says. And the court is required to decide how that notice is given. What's clear here is that my client, the defendants, did everything right. They followed the rule. They complied with the court's orders in relation to settlement. We paid $1.88 million into a fund. We did everything we were required to do.
Does the funding structure define the residual base? Why isn't it the 4.16 million?
Because, Your Honor, that was based on the March 18th order suggesting that because my client, who was just a management company, didn't actually receive these funds, did not have the records from the prior owners as to all the 10 files, that we were precluded from using this Yardy report as a basis for suggesting who had actually paid these funds in. We were precluded from that, and therefore we weren't allowed to use that Yardy report. We were sanctioned for that. That report, we always said, was the valid numbers. That said who paid it, how much they paid, and yet the court said, no, we can't rely on that. So the 4.1 million was an estimate of who could reply. We had no idea. In fact, we used the word ballpark to say this is what could come out of it.
So that's why the way you funded the structure of the funding is the cap on what's residual.
Correct, correct. And we funded this amount so that we could pay the claims. But again, Judge Liu was very clear on the structure of this. And with all due respect to my brother, Judge Liu was very clear on what the settlement was, that we were going to get back $500,000. Anything left after that would go to the Cypre
Do
recipients.
you know of any, can you give me any legal authority that has interpreted the phrase residual funds, or how to calculate what are residual funds under language that's similar to our Rule 23E?
I can't, Your Honor, but I think
I couldn't
the
find
rule
any. I
itself-
couldn't find any either. Well, the definition of residual funds goes only part of the way, because it doesn't tell you the base number from which those expenses are to be, or costs are to be subtracted. Do you know of any authority that would tell us or has decided what the base number is?
I don't, Your Honor, but I think that the second part is the important part. Nothing in this rule is intended to limit the parties from suggesting and the court approving a settlement that does not create residual funds. And that's exactly what happened here. Judge Liu, again, with 4 full hearings and a tremendous amount of pushback, said the fund will be the $500,000, no more going back to the defendants, and the rest being the residual fund. That's what expressly was discussed. That's what the agreement was, and that's what Judge Liu ordered to happen. And my client complied with that.
Well, I think that once your client agreed to a settlement that capped its liability at a certain number, that argument might be a little bit hard for you to maintain, because that number arguably is the base number for purposes of determining what are the residual funds, not just the decision as to how big a tranche to fund at a particular time. Anyway, but you don't have any case law or anything else that's going to help us figure that what the base is.
Not that we have found, Your Honor. And again, I don't even know if that's properly before this court, because, again, they don't have standing to raise that issue. The only standing they have is to say that they were heard. And again, Your Honor, I just want to finally note again that I don't know how we undo the settlement. My client gave all the money to these individuals around the country. They cashed their checks 4 years ago. We paid the attorney's fees for $1 million. I don't know how we get that money back.
But how about, I get the money that's been paid out. The issue is the money you kept. Isn't that potentially something that requires a review? Because that's different. I get, okay, those people got the money, those Cypre people got the money, and he doesn't have an ability to say IOLTA as opposed to the Cypre. But if the residual funds includes the money that went back to you, isn't that still fair game?
So I guess, Your Honor, I don't believe so, because, again, I believe the residual fund is the money coming back to my client, and that's what Judge Liu approved, and the court can't undo that and shouldn't be second
You believe it's
guessing Judge
not
Liu.
the money, I think you mean the opposite, right? The residual fund does not include the money.
Does not include, right. Could they be heard on whether or not the money should not go to these other charities? I think Judge Liu already ruled on that, and that's what Judge Howe was saying was the law of the case.
I find you persuasive on that point, but I'm still wondering whether the money that went back to you is fair game. 'Cause
I don't believe it is, Your Honor, because that's a settlement that we reached after hardy negotiations, use of a third-party mediation
What
service.
is the money that went back to your client?
I'm sorry, Your Honor?
So in response to Justice Kafker's question, you're talking about the money that went back to you, the money that went back to the defendant. What is that? 500,000? Are we talking about 500,000 plus whatever?
It's a little less than 500,000 because my client also had to pay some other expenses.
Why isn't it, why isn't it
Why isn't it the 4.16?
plus the 500,000? Yeah.
Because that was, again, a cap on what the total claims could be
Right.
up to.
Yes.
It was never the real number, right? It was what the claims made were going to be because, again, the judge had already said that this Yardy report that we were using was not reliable. So we had to do a claims made procedure because the court had already ruled that my client didn't know all this information as the managing agent, that we couldn't rely on this Yardy report.
I thought it was undisputed that these charges were imposed on all these people. They just, like everyone else gets those letters in the mail, they throw them away without doing anything. And then that doesn't mean that there weren't residual funds. It means people didn't bother to collect the money they were owed, and you kept it.
The problem, Your Honor, is you can't have it both ways. The court can't say that the seniority report is not a reliable source of.
Well, why not? I mean, you were sanctioned for failure to comply multiple times with discovery orders.
Because
That's separate and apart, and so you could no longer dispute that you were liable, effectively, for the security deposit law violation, right?
Because if on the one hand, the court is saying that you, management company, don't maintain thousands of tenant files for landlords that you no longer manage, their files, you no longer have those. And you say, here's the Yardy report, Judge, that has all the information. And the judge says, nope, that's not enough. That's not accurate. We can't rely on that. How then, when you get to settlement, do you say that Yardy report now suddenly?
Well, I thought that was partially because the Yardy report was under-inclusive, right? Part of the problem with the Yardy report is that there, at least according to the briefs in front of us, there were entire buildings that were not represented in the Yardy report. So to the extent the Yardy report was sanctionably incomplete, it was incomplete in favor of the plaintiffs in the sense that it was missing large part of the world. That doesn't mean that it couldn't be useful with respect to the people that it did capture.
Well, I guess, again, you can't have it both ways. If it's not.
Well, why can't I have it both ways? No. I just explicitly laid out a way that it could be reliable. It captured a world of people who paid these fees, and it seems to be undisputed that these people paid these fees, but it didn't capture a whole bunch of other people who were harmed by the conduct. And then you didn't do any notice to the world at large. You only wrote to the people in the Yardy report. So all of those people in other buildings have never gotten notice of this settlement.
Because that was the only information that we had, which is why we made it a claims-made procedure, and that's why Judge Liu approved that after 4 hearings, finding that that was the fair and reasonable way to do it. Thank you, Your Honors.
Thank you. Attorney Brown.
If it may please the court, Orestes Brown for the plaintiffs, Olivia Savarino and Matthew Ortins. Your Honor, admittedly, the IALTA committee received late notice. The final approval for the settlement was entered in July of 2021, and they should have received notice before that hearing so that they could have had an opportunity to be heard along with everybody else who was going to have an opportunity to be heard in July of 2021. But they received notice before the final distribution of what, at least at that time, the IALTA committee was claiming was the residuary, which was about $500,000. And at that time, they did not dispute the fairness of the settlement, but actually sought enforcement of it and asked the court to order $500,000 to be paid to them. So I believe the issue has been waived. On page 212 of the combined transcript, which I was just looking at, they asked the court to order enforcement and return $500,000. And that has been the gist of their request. And
Sorry, can you just spell that out? Order enforcement of the $500,000 to whom?
to them.
To them?
Yes, to them.
Okay.
Your Honor, they weren't, the point I'm making is they weren't disputing the fairness of the settlement agreement.
Well, they
They
don't
were
have
look-
standing to do that.
They don't have standing to do that. Otherwise, we would have another authority besides the court, and it would wreak havoc with the entire system. It would be discouraging for plaintiffs' attorneys like myself who are going to take these kinds of
As
cases.
to the argument they did raise, which related to residuals, right?
I'm sorry, Your Honor.
As to the argument that they did raise once they finally got this late notice, which related to residuals, what would we do about that?
Well, they were heard and judged. They have an opportunity to be heard, and the residual that they claimed existed still remained. They don't have an absolute right. And it is true that Judge Liu, he well considered all of the issues that were presented here today. We had 3 or 4 hearings that was seeking to settle a highly acrimonious litigation that was settled at jams. There was, the allegations of collusion are completely unfounded and misplaced. The duty of the plaintiffs is to the class. There was a long battle, as this court knows, over discovery where Lincoln refused to hand over all of the information regarding how many people had paid application fees and change lock fees. That was the dispute. And we had an estimate of how many apartments that they had, and we asked the court as a sanction to issue an order.
I agree that the base for the residual then is just whatever was in what I call the funding structure that the defendants had paid into. Or is it the 4.16 minus whatever the sort of admin litigation plaintiff's attorney's fees
Well, I believe that
and claims actually collected?
I believe that the base for the residual was at the most conceded at that hearing as being the $500,000. That was all that everybody was fighting about at that time. And that was a
And so if we think it was a mistake, it's just too late.
It wasn't too late.
No, now.
Is it?
Yeah, the fact that the three counsel agreed that it was 500,000 means that residual per the statute is just what has been agreed. Any other arguments to the contrary are waived.
I believe it's conceded that that's all that we're really fighting about. And that's how the deal was, and that's how the agreement was approved by Judge Liu. And it is unfounded that to suggest that Judge Liu didn't understand the final agreement as it was approved, because it certainly was before him. And every paragraph of
Can
that.
I go back to your concession, the concession? I can't find it. You said it's 212?
It's in the transcript appendix.
It's,
The combined transcripts.
have you seen it? Okay, all right.
Combined transcripts.
Can I ask you a related question? Assume we were to conclude that IOLTA has standing, that it's limited to appeal, that it's limited to the question of its failure to receive notice before the final approval of the settlement, and the opportunity to be heard before then. And further assuming that we were to agree with you that once IOLTA was heard, it took the position and therefore has waived any claim to the contrary, that the residual funds are, in this case, are limited to the $500,000. And so we wouldn't need to try to decide the more abstract question of whether in every case what constitutes residual funds. Wouldn't we still need to remand to permit IOLTA to then be heard on whether it should receive any of those $500,000? And couldn't we do just that limited amount without blowing up the whole settlement?
Your Honor, I believe you could do that. I believe they were heard. You'll see in the hearing, I didn't take a position in opposition to IOLTA's request at that hearing. My position at that hearing was basically no harm, no foul. They're here to be heard. There's a residuary remaining, which they are requesting be paid to them. And then the issue becomes, and I believe my brother made the argument at that time, was that there technically aren't any residuary funds because the judge ordered a distribution as we is allowed under the rule, which the rule, I admit, is unclear on that issue. And so I believed it was within the judge's discretion to decide either way, and she chose not to award any monies to IOLTA. And IOLTA doesn't have an absolute right, as we all know, and it's within the judge's discretion. So where can it go from there?
Let me ask you, which probably is an obvious question, and I apologize. Was the monies paid to the Cypre recipients?
$100,000 was inexplicably, without authority, although I have no contention with
It
it,
wasn't a stupid.
paid to one of the side prey recipients, North Shore Community Development, which is one of the side prey recipients that was specifically requested by Judge Liu. He wanted a housing-related site, so we came up with Action Inc., both two reputable affordable housing builders. So North Shore Community Development got 100,000 out of their 120 some odd thousand. They have some more money coming to them under the terms of the agreement, and Action Inc. has received none. And there are, I think, 12 claimants that have yet to receive. Only 12 have not received their payments. That it was held up, and I am receiving communications from all of them about why don't we have our money?
The second side prey recipient received nothing.
Nothing.
Thank you.
And the 500,000 they limited themselves to was the 500,000 returned to the defendants. That's the 500,000 we're dealing with.
Well, that hasn't been returned to the defendant. That's all frozen.
Frozen. I got you. Sorry. Yeah.
Okay.
So thank you.